Hi, I'm Leigh York from Fort Worth, Texas. I was the 2020 chair of the Professional Standards, Interpretations, and Procedures Advisory Board. My committee actually wrote the recommendations that were eventually approved by the Professional Standards Committee and then the Board of Directors on November 13th of 2020. So I spent an hour with some Kansas City realtors today talking about those changes and how they'll actually be applied and enforced. And so I'm going to spend just a little bit of time on recording this for you so I can share with you that conversation and some of the things that we talked about. So, I have shared the screen, and that's just the stuff about me, so you don't care. Let's look here. So Article 10. Article 10, we've always referred to as the Fair Housing Article. It says that we can't, as realtors, we can't discriminate or participate in a plan to discriminate against any of the protected classes that are listed there. It also says that we can't use those protected classes as consideration when hiring either, or it says employment. That was added in 14. So those protected classes, it's important to recognize that those are the protected classes under the Code of Ethics. They are the 7 federal protected classes plus 2 that were added to the Code of Ethics. Your jurisdiction, your city, your county, your state may have additional protected classes, but those are not enforceable under the Code of Ethics. We're not enforcing the law. We're just the Code of Ethics. Okay. So we added 10.5. So effective November 14th of 2020 is Standard of Practice 10.5. 10.5 says realtors must not use harassing speech, hate speech, epithets, or slurs based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Okay. So again, it's important to remember that it's only those protected classes. If it's not in that list, then it doesn't count for us. Okay. Now, another thing that is important to remember when we're looking at these cases, you may think, well, my definition of harassing speech is different than Leigh's definition of harassing speech. So how can we possibly have continuity in our decisions and enforcements of the rules? Well, the matter of it is that it doesn't matter what Leigh's definition is, and it doesn't matter what your definition is. What matters is the definition in our manual. So as grievance or hearing, when we're looking at these complaints, the first question we ask ourselves is, does this speech or this action meet these specific definitions of harassing speech, hate speech, epithets, or slurs? If they don't meet that definition and there's no way that they can, then that complaint isn't going anywhere. If they do meet that definition, then the next question is it directed against one of those protected classes that are listed in Article 10? Okay. Now, I get all of us are members of one or more protected classes, but the speech or action has to be directed at one of those protected classes, right? They, maybe you see something that is hate speech against a political party, right? And whatever they're spouting there might also be of a particular gender, okay? But if it's directed at the political party, then it's not a violation of Article 10. If it's directed against the gender, it might be, right? So it has to be something that is directed at one of those protected classes as listed in Article 10. So anytime a grievance committee meets and considers complaints, they have the same question, right? If the information before us is true, is it possible that there is a violation? And so that's the very same standard when grievance is looking at a complaint on Article 10. If the information before us is true, is there a possible violation? So if this meets the definition as we have in the manual, right? And is it directed at a protected class? those answers have to be yes before we forward it to a hearing. If they're not, we dismiss it. If it goes to a hearing, then a hearing panel, again, just like with any complaint on any article, the hearing panel is going to hear both sides of the story. They're going to hear all the testimony and see all the evidence that's put forth in order to make their decision, right? So if you see on the screen, I've actually got 3 questions there. A yes answer to 1 and 2 makes it a violation. It is a violation if the answer to 1 and 2 is yes. And that's the same 2 questions I've been asking. Does it meet the definitions of harassing speech, hate speech, epithets, or slurs? And is it directed against one of the protected classes? If the answers to both of those is yes, then you have a violation. But now it's time to think about sanctions. So one of the things you might consider when you're determining sanctions is, does this indicate an inability or an unwillingness to provide equal professional services to that protected class that this speech was directed to? And if you feel like it does, then your sanction is going to be a little higher than if that isn't what they meant at all, right? And all of that comes out through testimony and looking at that evidence. And that is really the basics of it. It is very narrow. Okay. Again, it does not include political parties. It's not, it is not meant to say that a realtor can't talk about anything or express opinions. Okay. It's meant to keep realtors from going out into public and saying and doing things that reflect on all of us as if we were discriminatory. There were some questions asked in the session that I want to repeat for you here on the recording. Back when we first put the recommendations out for consideration and all of the directors were, reading and reviewing and vetting for, a little more than a month before they were going to be voting on it, one of the directors posted, a really legitimate question. And she said, there is a lot of discussion. I'm in this group and I don't remember which sport it was, so I'm just going to use basketball. And I know I'm getting that wrong, and I'm sorry, but I don't remember. But the case was she was saying, we have more and more transgenders in this women's sport. So I'll say women's basketball, right? And now we've got transgenders playing with and against women in this sport. And I have a real problem with that. And if I share my feelings that that's not fair competition, am I in violation of the code? And what we all agreed on is, first of all, it's going to be up to the hearing panel, right? What comes out in that testimony, in that hearing? What do you say? If that respondent is saying, negative things about transgenders and focusing some kind of hate or harassment against the transgender community, then yeah, it's probably a violation. But if they're simply saying, I don't think this competition is fair, and this is why, because this transgender may have more muscle mass than the other women on the team, right? Something like, then that's not hate speech or harassing speech that's directed at this protected class, right? So that's something completely different. We were also asked about case studies. NAR does not put out case studies till we've actually had cases. So I will tell you that at this point, when I'm recording this, nothing on Article 10 as supported by 10-5 has gone completely through the process. So we don't have anything that's gone through a hearing with sanctions imposed and, the decisions made. We do have some complaints and some things that have come out of grievance. So we're working on some case studies. The advisory board has got 4 or 5 meetings scheduled between now and midsummer. or early summer actually. And then the Professional Standards Committee will meet at least once, maybe twice before May. So we're hoping that in May, we will have some good solid case studies to put before that committee to approve. And once they've approved them, then they can be shared and utilized as a tool for you. What else? Disciplinary action. So the disciplinary actions can be, the examples of disciplinary actions can be found in section 7 of the Code of Ethics and Arbitration Manual. And there were some changes to the examples and the disciplinary action, language in that section. None of the meaning was changed. It was all about clarifying what was already there. And there was kind of like a wives' tale out there that you could only look back 3 years for prior violations, and that is not true. It really is just a myth, but we understood why people had that impression. So we went in and changed some of that language, gave some, different examples for stages of sanctions, for sanctions to be progressive. We just did a webinar through NAR that's posted on nar.realtor about sanctioning guidelines, right? And specifically the changes in or not changes, but the updates. And we talked a lot about when something is a violation of the public trust. So any Article 10 violation, certainly anything that's discrimination or fraud, that's a violation of the public trust. And we do feel that anything that's a violation of the public trust is certainly more egregious than, in my newspaper ad, I left ink off the brokerage name, right? Those are two different things. They're not and shouldn't be on the same scale. So, I would hope that when you find a violation of Article 10, whether it's supported by 10.5 or any other of the standards of practice, when you find a violation of Article 10, that's not a letter of reprimand, right? That's some education and maybe a fine. And depending on what comes out in that hearing as to how far you go, it may be that all they need is a small fine and some education, or just the education, right? Because they recognize that they've made a mistake and why, whatever. But if you've got someone in that hearing saying, I should be able to discriminate, I should be able to say these things and I don't agree. And, now you've got someone who is knowingly violating the rules and putting out that discriminatory behavior. So I would hope that your sanctions would be much higher. And remember that sanctions can be from $0 to $15,000. So you've got a big range there to work with, along with education, and eventually they can be suspended from MLS or even membership. So you've got a big list of sanctions. You're going to process these cases just like any other complaint on any other article. You're going to use your manual, stick to your training, be unbiased, and go through the process. What else did we have? Oh, speaking of that, we talked about when you might want to recuse yourself, right? We know that if you have a conflict of interest, or, somebody, the complainant or respondent is your brother-in-law or in your office, or, we all know reasons that we recuse ourselves. But I want to remind you that if you have, a strong feeling on either side of this issue, right, on an Article 10 complaint, if you're completely against 10-5, or if you think that everyone who makes a mistake is automatically a racist, right? If you're on either side of that and you can't keep that out of the room, then you need to recuse yourself. And I would rather you recuse yourself than to go in and not give someone that due process that they all deserve. So, keep that in your mind. What else? Oh, we talked about bias training. So in Kansas City, there is some bias training that's available to you. It is not required for you to serve on these kinds of cases, but it is encouraged. The more you know, the better you are. So that is out there. We talked about we gave a religion example. I often get the question about what if I'm a realtor and a preacher, and I'm in the pulpit and I say that homosexuals are an abomination. If that realtor slash preacher is giving that sermon and says that, but kind of leaves it there, right? I don't think that's hate speech. Again, it's going to depend on what's said at that hearing. But that in itself, that by itself does not sound like hate speech to me. Okay. Especially since I know that that pastor is probably in the same sermon going to remind you that the Bible tells us to love everyone, to love one another, love thy neighbor, right? So when the line is crossed is when they say it's an abomination and you've got to take a stand against them and they shouldn't be in our neighborhoods and they shouldn't be in our school, those kinds of things. That's an example of when that line might be crossed into a violation of Article 10. We're always getting asked about the First Amendment. So the First Amendment says that the government cannot interfere in our speech. They cannot censor what we have to say. But I would remind you that NAR is not the government. The lawyer answer to that question is always going to be NAR is not the government, right? It's a private organization, and they have every right to censor your speech, right? Just like your broker does, by the way. But I'll also give you the realtor answer. And the realtor answer is, when you're out there acting like a moron, it reflects on me as a realtor as well. And that's not okay. So, yeah, we're a private organization. We were established to protect the consumer from, unethical real estate practitioners in the marketplace. That's why we were established. And we are meant to set a higher standard. And this is a place where we've set a higher standard. And, we certainly don't want to run members off, but at the same time, you have the freedom of leaving the association if this is something you can't stomach, if it's not a higher standard that you want to meet, or maybe you don't see it as a higher standard, right? That is your personal choice. We feel like it is a higher standard. And we also feel like it's not going to affect 95% of the realtors because they're not out there doing this kind of thing anyway. So I think I'm looking at my list real quick. There's one more thing on my list. So the question was asked, if you're on social media and someone posts something that is, most likely a violation, and you hit like or you share that post, could that be a violation? And again, it's going to depend on your hearing panel, but my personal opinion is, yeah, probably. Because when you say you like something, you're endorsing it. And when you're sharing something, you're certainly endorsing it. You're saying, not only do I like that behavior, but I want all my friends to see it, right? So that, in my mind, that's the same, so I think there probably is a violation there. Now, in order to determine sanctions, I want to hear that story. I want to hear what happened, why they did that, I need to hear the whole story before I know where we're at on that. But on the surface, is that a violation? Probably, in my opinion. So that is all that is on my list. I know that I went really quickly. The only other thing we talked about was resources. There are lots of resources for you. NAR.realtor, right? Lots of resources there. There are monthly webinars that we've been doing, educating on different aspects of the changes and the enforcement of those changes. There is Fairhaven.realtor, which is, I love Fairhaven.realtor. So Fairhaven.realtor, if you haven't heard of it, it's like a game, right? You go to fairhaven.realtor, you sign up, and by the way, it's completely anonymous. They do not share it with, there's no way your broker gets a hold of this or anybody else. Okay. It's all confidential. But you go in and you have these tasks and you play this. It's a game. And you want to win. By the way, it's fun, and you have the opportunity to simply not discriminate, or to actually be an advocate for your clients, right? And to be against discrimination. And you go through the game, and then at the end, you get two scores. You get one that tells you, it grades you on how well you know the rules. And then you get another score that grades you on how well you apply the rules. So it was really fun and eye-opening. So I love fairhaven.realtor. There's implicit bias training. Debbie Strange with your association has a list of resources that I know she'll share with you. There's also some resources on my website. It's up there, leispeaks.com. Just go to resources. Everything there is free. There's even a handout that includes the information that was in the slides that I played at the beginning. So I hope that you find this very helpful. I wish you the best of luck in your professional standards journey, and have a great day.